The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to our webinar, The Do's and Don'ts of Hiring Independent Contractors and Potential Employee Misclassifications. My name is Julie Dorr and I'll be your moderator for today's event. Our presentation will last approximately 40 minutes with the remaining time available for your questions. If during the presentation you have any questions at all, just feel free to type them in that designated questions area. We're going to handle all questions at the end of the presentation. So if you put them in there, we'll kind of put you in the queue and then we'll ask those questions of our presenters today right at the end. And earlier this morning, I did email a link to a copy of our presentation that you could download. If you haven't received that, feel free to email me right now at julie@thedoorgroup.com, and my email address is right there on the screen, and I'll send you that document right away. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. So let's get started today. I want to introduce our panelists. You know them well. First of all, we have Linda Duffy, and Linda is the president of Ethos Human Capital Solutions. Linda works with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. And then, of course, we also have attorney Marla Merhab Robinson. Marla's with the law firm Merhab Robinson, Jackson & Clarkson, where she is a partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and employment law. And Marla's going to get us started today. So Marla, I'm going to turn it over to you.
Thank you, Julie, and welcome everyone. Very happy to have all of you here. And we're going to start with our agenda, which we're going to give you a little overview of the law, some examples of the costs of being wrong if you do misclassify a worker as an independent contractor when they should have been an employee. Some suggested corrective action or plans if you determine after this webinar or after discussing with Linda or me or another attorney or consultant that you have an issue with misclassification. Some examples, a lot of examples, true stories, true cases, and then Q&A. We try to have some time for Q&A. I think this is a real appropriate time to have this webinar. Linda and I last did this webinar 2 years ago. However, it's really good timing now because many of you may have seen earlier this year a San Diego court awarded a class of workers who were newspaper delivery men or delivery boys, girls. They're often young. $4,953,000 and $4,953,795 after determining that they were misclassified as independent contractors. That was actually reimbursement of expenses that had been deducted from their payments, their wages. And then in addition to that, attorney's fees, over $6 million. The same law firm, it's a local Santa Ana law firm that handled that case, also sued the Register. That one was for a San Diego newspaper. It also sued the Register here in Orange County and settled that case back in 2009 for $38 million. They have two similar pending lawsuits against the Sacramento Bee and the Fresno Bee. In addition, you may have seen that just last month, FedEx, who's had a lot of trouble lately, settled claims of misclassification of its drivers in the state of Maine, and that was for $5.8 million. So at our agenda, item number 2, costs of being wrong, very, very significant, which we'll also show later. But I just wanted to point out that I think that the timing of this webinar is perfect. So an independent contractor, who is an independent contractor? An independent contractor is a person in business for him or herself who performs services for others. They are engaged to perform specific tasks, generally, not broad tasks, and the manner and means of performing the tasks are within the control of the independent contractor. More specifically, it's one who is engaged to perform services using his or her own methods of operating. And often an independent contractor can be an entity. So it can be a corporation or an LLC or LLP. It doesn't have to just be an individual. That word person with a capital P is defined in most statutes as also including entities. So that's the definition of an independent contractor. If we look at Labor Code Section 350, we get the definition of employer, which is every person engaged in any business or enterprise in the state that has one or more persons in service under any appointment, contract of hire, or apprenticeship, express or implied, oral or written, irrespective of whether the person is the owner of the business or is operating on a concessionaire or other basis. And it's important to note here that that person word again is not capitalized. But of course we all know the employer can be the entity, corporation, LLC, LLP, and the like. And the definition of employee is also in the same Labor Code section and includes every person, including aliens and minors. Often I'm asked if illegal aliens are included for protection under the wage and hour laws, and they are. Rendering actual service in any business for an employer, whether gratuitously or for wages or pay, whether the wages or pay are measured by the standard, piece, task, commission, or other method of calculation, and whether the service is rendered on a commission, concierge, or other basis. For purposes of determining independent contractor versus employee, we look at a definition that an employee is subject to will and control of the employer, not only as to what shall be accomplished, but also as to how it shall be accomplished. And as you'll see as we go through this, these are very gray terms and not well defined in black and white, which makes the investigation as to whether or not someone is an independent contractor or an employee very factually intensive on a case-by-case basis. So our next slide, examination of contractor status. Who determines independent contractor status? This is probably the biggest battle I have with my clients and potential employers who seek out advice regarding misclassification. I'm very often told, I have a written contract with this individual. It says this individual is an independent contractor. He or she wants to be an independent contractor. I want him or her to be an independent contractor. Well, unfortunately, the parties that are contracting don't get to decide for themselves. The parties that do get to decide are those you see on the right of the slide, and that's the EDD, the IRS, the FTB, Franchise Tax Board, for those of you who don't know, the Department of Labor, both the federal department and the California Labor Commission, which is the Division of Labor Standards and Enforcement, the INS, and the Workers' Compensation Appeals Board. These entities have the ability, as well as the courts, to determine whether the worker is an independent contractor or an employee, and they don't look to the intent of the parties. It doesn't matter if the parties intended for independent contractor status. What matters is the tests that we're going to go over. Linda is going to go over in detail after I go through them in general terms. That the point here is to note that the courts and the legislature and the administrative bodies that are listed there have not set specific universal standards. Everything is done on a case-by-case basis that's factually intensive in investigation. I want to give you a real-life example here of a client and a good friend of mine whose company hired an individual who even claimed to have a business license and a separate business and claimed to work for other businesses. They hired this individual as an independent contractor, had an independent contract agreement that she provided to them. And unfortunately, when the EDD came in, she made a claim for unemployment insurance. They said, no, we have to go through the tests, which we're about to go through, and she doesn't meet the tests of independent contractor. Specifically, in this case, she was coming to work every day at the employer's place of business at the same hours, using the tools and instrumentalities of the employer, and doing work at the direction of the employer. It was very unfortunate to find out the same individual pulled what I would call a scam because she convinced the employer that she was an independent contractor on another employer later. And of course, both employers lost to her claims. She was found to be an employee. So what are the tests? The next slide, the 20 common law tests. Now the federal agencies we identified and the state both use these tests, some more than others, but these are the 20 most common and the common law tests. the first, instructions. Who's giving instructions? Is the employer giving instructions on either how to do the work or the results of the work? Because if the employer is, then it's more likely an employee than an independent contractor. Training. If the employer, or if you prefer to use the term hirer, but it's still an employer even if the worker is an independent contractor. But if the employer or hirer is providing training, that leans more towards an argument of an employment relationship and an employee. Integration with the current workforce, that leans towards an employee. Services rendered personally, that leans more towards an employee. Not necessarily absolutely an employee, because I can give an example of an independent contractor who provides services personally. For example, I have a CPA who comes into my firm 2 days a week and performs accounting services, but she also owns her own business and performs those services for others. She doesn't work at my direction and control. She actually can come in any 2 days she wants. She knows how to do accounting without my training. She's not integrated into my employment force. So all of these things bear on the determination. Again, hiring, supervising, and paying assistance. If the independent contractor has, if the worker has the ability to do that on their own, then they're more likely to be held to be an independent contractor than an employee, because employees don't generally have the right to do that. A continuing relationship, that's generally a sign of an independent contractor, because the relationship usually lasts until the job is done. With an employee, as you all know from our prior webinars, we work hard to keep that at will, meaning we can terminate you at any time. Contractors generally don't get terminated until the work that they were hired to perform is done. Set hours of work and full-time required. If they have the ability to set their own hours, that's indicative of an independent contractor. If they're required to work full-time, that's going to lean towards supporting an argument that it's an employee. Doing work on employer's premises, that's going to lean towards an argument that it's an employee, as I said in my example. Order or sequence set, if the employer is dictating the order of how the work is performed, then it's more likely going to be an employee. Oral or written reports, generally this is going to be leaning towards an employee, but oftentimes independent contractors are also giving reports based on what's been completed, because they often get paid on completion of work performed. I'm hoping as we're going through these that you're getting the gist that it's very factually intensive investigation on each potential classification. Payment by hour, week, and month, that's generally you pay your employees either by hour or bi-weekly or monthly. Independent contractors are generally paid either monthly or upon completion of certain work, so that we look at those terms to see where we're leaning. Payment of business and or traveling expenses, that actually falls on both. Employees are required by law to receive reimbursement of expenses. Independent contractors often maintain their own, but will also sometimes be reimbursed depending on the industry that they're working in. Furnishing of tools and materials, this is a big one. Independent contractors provide their own tools. Employees are provided the tools, and that includes office space. We call them tools and instrumentalities of the employer. I have a client who is in the construction business and thought that all of their workers were independent contractors, but because they were bringing their own tools. But unfortunately, when you looked at the other factors, they were working the days and hours when required by the employer and under the supervision and control of the employer. They had a supervisor there telling them exactly what to do. The decision came down in favor of employee as opposed to independent contractor. Significant investment. What we like to see with independent contractors, or what the deciding bodies like to see, is that there's some capital at risk, that they're running a business, that they've got some of their own money at risk as an investment, that if they don't perform, their business may go out of business. That's the same with realization of profit or loss, that if they do perform well, they're going to receive a profit. If they don't, they're going to have a loss. They have that same risk. Working for more than one firm or client or customer at a time, that leans towards the argument in favor of independent contractor status. Same with making service available to the general public. And the right to discharge and the right to terminate I spoke to a little bit earlier. If it's at will, it's going to lean towards an employment relationship, and if it's some period of time or upon completion of some project, it's going to lean more towards the independent contractor status. So what if we're wrong? As my introduction suggests, the risks are extremely high and very, very expensive, even with a small firm, because of the penalties. So there are potential criminal penalties, although I've never seen any in California. It's a growing trend in many states, and the federal government has tried to adopt laws to provide criminal penalty. I've not seen or had any of my clients experience any criminal violations. But civil liability, quite a bit. And the penalties and interest can potentially be more than 110%. And that can include unpaid federal and state income taxes and withholdings, with Social Security withholdings, Social Security and Medicare contributions, unpaid workers' compensation premiums, overtime, reimbursement of expenses, health benefits, everything that an employee was supposed to get, which is quite a bit from the employer, that the independent contractor didn't. And again, it doesn't matter that the independent contractor didn't want these things. They're entitled to them. Some of you may remember that Microsoft settlement with the IRS a couple years ago with regard to health benefits, maybe even last year, was $97 million. $97 million after misclassifying several workers, obviously, as independent contractors when they were actually employees. So in 2012, Obama administration budgeted approximately $14 million to hire more investigators in the Department of Labor to do what they called detect and deter employers from misclassifying. So if you think they're not out there looking, you're wrong. They are. You know, the federal government needs money, the state government needs money, and this is a place to go get it. Also in 2012, California adopted the California Independent Contractor Law, and it prohibits willful misclassification and adds new hefty penalties and joint liability for people outside who advise employers to classify someone as independent contractors when they should be employees. Not lawyers. Lawyers got excluded, and that's probably because lawyers write these laws, not because they should be in a protected class. But so if, for example, if you use a consultant like Linda, and she encouraged you to misclassify someone willfully and intentionally wrong, then she has potential liability as well. So that second bullet point on the slide gives these new hefty violations between $5,000 and $15,000 per violation, and $10,000 to $25,000 if there's a pattern or practice, meaning this is something that's been occurring for some time by the same employer. There's also what I call a mommy slap on the hand, which is the requirement to prominently display it in the place of employment for the general public to see a notice which says, we did wrong, we're in trouble, we got caught, and we've been ordered to let you know this. So who is liable? Certainly where it says corporation, I encourage you to cross that out, right? Employer, the employer, because that could be a corporation, could be an LLC, could be a sole proprietorship, could be a partnership, could be a limited liability partnership. So that's an error on our side, and I apologize for that. But the employer is certainly liable. But in addition to that, under federal law, under the IRS, individuals, personal liability, which is unusual in most of our employment law claims that we give our webinars about. There usually isn't personal liability so long as the principals and officers and directors of entities have followed their organizational rules. Sexual harassment is something that's a little bit different. You can have personal liability there, but generally there isn't personal liability for employment law claims. But here, definite liability to the IRS for all unpaid taxes, including the income taxes of the worker if the worker didn't pay their income taxes. So this is a huge penalty. And so now I am going to turn it over to Linda Duffy.
Well, thanks, Marla, and welcome, everyone. That was great, as always, Marla. I appreciate especially that slide that has all 20 factors on it. So Marla just went through all of the different things to consider as to how to properly classify people, or whether they should be employees or independent contractors, and what the potential liability is if you've misclassified someone. So the question is what to do about it. Suppose you've done your own internal audit and you've decided, we've decided that we think that we have misclassified a few people. What do we do? Well, you have some options. Clearly one is just to classify them as employees and move on and sort of stick your head in the sand and hope that no one ever finds out. That's certainly one possibility. The federal government actually has their Federal Voluntary Classification Settlement Program, VCSP, and that is essentially allows you to go back and reclassify workers where perhaps you've been calling them independent contractors before and you've been paying them through accounts payable, and now you want to go back and say, you know what, we want to raise our hand and sort of go surrender, you know, we want to move forward and put them on our payroll. This gives you the opportunity, sort of almost like amnesty program, to come forward and say, okay, our bad, we want to move forward and do the right thing, but of course the government still wants their money, right? The good news is if you go through the voluntary program with the federal government, you're limiting your financial liability, and the way they do this is they go through and they say, okay, if you fill out the form and assuming that you qualify under this program, and there's some qualifications, then you would have to pay 10% of the prior year's employment taxes, and it's calculated under a special rate structure. Okay, that all sounds well and good, and roughly what that's going to come out to be is 1 to 2% of the wages paid to those reclassified workers. So to do the math for you, let's say you look back and you said, okay, if we had had all of these independent contractors on payroll last year, our compensation that we would have paid them would have been $1 million. Then the tax payment is approximately $10,000 to $20,000, and all of the money is due at the time you submit your paperwork. So you're going to fill out their application process, you're going to go through, and you're going to write them a check based on your estimate of this program. Now, there are certain requirements to qualify under the VCSP. You can't just unilaterally go and say, hey, I want to do this program. You have to have consistently treated the workers as non-employees. So you can't have some of them on payroll, some of them not on payroll. You can't change it up year to year. You will have had to have filed all of the 1099 forms for those people for the previous 3 years. Now, they've done some changes to this program since then. If you haven't done that, there still might be a way around it, but generally they want to see that you're playing by federal law anyway, which means if you really in good faith thought they were independent contractors, you should have filed a 1099 form on them. You cannot currently be under audit by the IRS for any reason. You can be under IRS examination, is the different word to them, but not an audit, and you can't be part of an affiliated group who is. So if you are already under audit, you can't just all of a sudden jump in and go, hey, wait, we want to file this form and write you a check before you get caught. I mean, they're not that dumb, right? And you cannot be under audit by the Department of Labor or any other government agency concerning the classification of workers. So this isn't meant to be like all of a sudden you're already busted, but before they figure it out, you want to voluntarily enter this program. You have to agree not to contest the worker classification in court. You have to complete the application, and then you have to enter into what's called a closing agreement with the IRS, and this means that you are basically promising that going forward you're going to treat this class of workers as employees. So you can't fill out the form, do it, and then next year go back and have them as independent contractors. And then, as I already mentioned, you have to pay the full amount due under that program when you submit that closing agreement. So I misspoke earlier, I said the application, but the closing agreement part. Now, that sounds all well and good, and there's certainly some benefit to going into that program. The problem is California doesn't have such a program. So California, you don't have that type of amnesty or that ability to sort of go in and say, hey, our bad, we want to fix this problem. So the question you have to ask yourself is if you file under the federal program, you know, for this, we'll call it amnesty, does the IRS notify EDD? Now, if you go to the EDD website, or maybe even the DLSE website, they say they don't work with the IRS on anything like this. So personally, you know, I don't know whether to believe that or not, because I think we've all seen under different audits, or when one agency comes in your door to, you know, to look at something, they certainly have the ability to call their counterparts and, you know, shine a spotlight on something. Now, what the EDD website does have is it says, who do I contact if I have questions? This is straight off of their website. They do have a hotline number you can call Monday to Friday. You can also call their Taxpayer Assistance Center. So they do give you options if you want to reach out to them and say, hey, confidentially, what do we think if, you know, I've been you know, I think I've determined I've misclassified somebody. What do we do? And you can reach out to them for help and see what they say. Okay. Now, just be really careful about all of this. You know, Marla's told you some stories. I'll tell you one of mine. Had good friends who have a business down in San Diego County. They had hired someone or engaged someone, I should say, to transcribe tapes. So they do a lot of seminars and other public live events. They often tape record them. They want them transcribed. So they engage someone. They never met the woman. And you go back through Marla's list of 20 things, never met the woman, didn't provide her with any sort of equipment, she didn't come on their premises, they didn't tell her how to transcribe the tapes, you just go down the list, and they were paying her a flat fee, I think, per tape. They weren't even paying her like by the hour. The woman had a full-time job working for somebody else, doing something else, and what happened was she was laid off from her full-time job. And when she went to file for unemployment, there's a question on the form that always says, okay, who was your last employer? So she mistakenly listed them as her most recent employer, and EDD on their own decided that she was actually should have been classified as an employee and was causing my friends and client to go back and reclassify her and pay back wages, back penalties, everything else. So it can get pretty nasty, as Marla's pointed out. So I'm not saying don't go forward and try to resolve the problem. Just, you know, figure out ahead of time, maybe get some counsel from an attorney, call anonymously and talk to someone at the state, do whatever you have to do. You certainly don't want to continue to perpetuate a problem willfully, as Marla pointed out. There's additional penalties for that. Just be really careful if you decide you're going to reclassify people that you do it correctly. And with as much amnesty as possible. So here are some basic classification questions you can ask yourself, and we are actually going to make a document available to you after this website that has all these questions on it. So the 3 basic classification questions to ask are, do you instruct or supervise the person while they're working, right? Can the worker quit or be discharged or fired at any time? And is the work being performed as part of your regular business? Is that part of your regular business? And if you answer yes to any of these questions, it is a very strong indication that the worker is an employee and not an independent contractor. So start with these 3 and ask yourself, you know, who's instructing or supervising the person? And if the answer is this manager is, our company is, or whatever, or if we can, you know, can they quit or can we fire them at any time, you got to believe that this person is probably meant to be an employee and not an independent contractor. After you get through those basic questions, then go to what we're calling like the Tier 2 questions. So does the worker have a separately established business? Okay, maybe they have a business license, anything like that, but they're doing something. Is the worker free to make business decisions which affect her or his ability to profit from the work? So Marla referenced this before. It's sort of tied to number 3. You know, is there a substantial investment which would cause this worker to have some sort of financial risk or loss? So can they make as much money? Can they sort of dictate how they make profit? Can they price their services how they want them priced to ensure that they're making a profit? And then the 4th question, if the work performed requires a license, does the worker have such a license? So when you look at those 4 questions, if you answered no to any of those, then again, most likely the worker is an employee. So if you're talking about somebody that has their own business, they're establishing their own pricing, they have a license maybe to do the work, then you're probably okay in having them as an independent contractor. Some additional questions that you're going to want to consider is, do you have employees who do the same type of work? Now, I do have a client that's in the logistics business. They have some truck drivers who are employees, and they also have some owner-operated drivers who have their own truck. So again, that's just a red flag. They have looked into it with their legal counsel, and they've assured me that their legal counsel gives them a thumbs up. But that's the type of red flag to look at, you know, when I go in to audit them or talk with them, and I go, wait a second, you've got 2 distinct classes doing the same type of work. That could raise a red flag to somebody. Do you furnish the tools, equipment, or supplies used to perform the work? Marla mentioned this one before. Is the work considered unskilled or semi-skilled labor? Because again, usually you're hiring independent contractors to provide their expertise. You know, you don't, for example, you might engage me to come in as an independent contractor. I have my own business, a business license, the whole thing. I'm a corporation. You wouldn't necessarily hire an HR clerk to come in and sit down at a desk and actually do, you know, processing transactional level work. Do you provide training for the worker? If you have to train the worker, again, they're not bringing their expertise to the table. Did the worker previously perform the same or similar services for you as an employer? This one actually comes up a lot. I've had employers or clients that come to me that say, yeah, you know what, this person just left, but we're going to bring him back as an independent contractor. You know, he left us, he went to another job at another employer, but we're going to put him on an independent contractor agreement. And I'm like, nope, that's not really the right way to handle it. So again, if they have some level of expertise, if they're a high-level individual, you might be able to get away with it under certain circumstances. But what I tell them is just leave them on payroll as a part-time employee or as as-needed employee. That would be the easier way to do it. So again, if they were an employee today, tomorrow they're probably not going to be an independent contractor. Does the worker believe that she or he is an employee? So you ask yourself that, like, what is their understanding? Because again, like in the example I gave you with my friends, maybe that woman thought she was an employee. Maybe she thought she should have been on, you know, on payroll so she could collect unemployment. Don't know, but you need to make that really clear. And then, is the worker eligible for any benefits? Clearly, employees are eligible for benefits. Independent contractors are not, and so you want to make sure that you're not offering them any benefits. And that's even gone so far sometimes, and Marla might know some case law on this, but that's even things like inviting them to company functions, company parties, all sorts of stuff. Okay, so let's just look at some quick examples, and I don't have to read through all of these because they're all written out for you, but you know, here are some examples of where things might be similar on the surface but are different in how they treat them. So an independent contractor example for an attorney or accountant is somebody who has their own business, they advertise somehow, Yellow Pages, website, whatever, under attorneys or accountants. They bill clients by the hour. They're engaged by job or maybe have an annual retainer. They can hire a substitute to do the work. They don't have to personally do it. That person is probably an independent contractor. But then you look at an attorney or accountant who actually is employed by a firm to handle the legal affairs or financial records, works in an office at the firm's place of business, attends meetings, that type of stuff. That's probably an employee. And that could be an employee of the law firm or accounting firm, or it could be somebody in-house at a corporation. Okay, the next example is an auto mechanic. You know, there'd be a difference. An employee would be an auto mechanic who's actually working at somebody else's shop, and they're probably getting an hourly rate, or maybe they're paid per diem or something. But the auto shop is telling them when they show up, they're providing tools and equipment, they're telling them, you know, how to keep records of their time, they're giving them instruction, maybe some training, as opposed to the independent contractor who has a station license, a resale license, they buy the parts, they set their own prices, they do all the collections from customers, all of that. That would be an independent contractor example. Okay, example number 3, a dance instructor. If you're working inside a health club, working for somebody else, you're going to be an employee. They're going to dictate the hours. They're going to have you show up, yes, and do the work for them, but the instructor is going to be paid by the health club in this particular example themselves. As an independent contractor, the dance instructors are going to do everything on their own. They're probably going to have their own facility. They're going to have all different customers come in, not beholden to any one gym or anything like that. They're going to have their own equipment like sound systems, music, clothing, all those different things. And finally, our 4th example, a repair person similar to the auto mechanic, a repair person that owns their own shop, that advertises, that has tools and equipment of their own. They're going to do their, setting of their own prices, ensuring that they can make money. They're going to handle collections, all of that as an independent contractor. And then somebody working in a shop for somebody but doing repair, where they're going to get paid by the hour, or by, a percentage of the work done. They're going to be turning in timesheets. Everything like that's going to be an employee. All right, so what can you do in terms of best practices? What we're recommending is, first of all, make a good faith effort to properly classify people, obviously. Go through the questions, take a look at the slide that had the 20 different factors on it, and then also go through the 3 slides that have the questions. Again, we're going to provide you with a document that has all of those questions, and it also has some analysis. Marla's done a really good job for her clients with that, so she's happy to share that with you. If you do believe that you've classified them properly and you have independent contractors you've engaged, make sure you get a Form W-9 filed from each one of them. I know a lot of my clients, even though I'm a corporation and they don't need to issue me a 1099, they still request a Form W-9 from me every year, which I'm happy to provide. And then also what we would recommend is ensure that the contractor is going to enter into an agreement with you. And again, Marla's point was well taken early on. You're not an independent contractor because you've entered into an agreement. Okay, don't misunderstand what I'm saying. I'm saying if they are an independent contractor, make sure they do enter into an agreement. Okay, the agreement by itself does not make them an independent contractor. And what I would recommend is provide proof of a license if it's important to have one. In some instances, you might want to ask them whether or not they have a, if they're a corporation or an LLC or something like that. And then provide proof of liability insurance and workers' comp if the contractor has employees who are going to be coming on site. And depending on the type of work, if it's any sort of repair, construction, anything like that that you've engaged, you might want to have them added as have yourself added as an additional insured on their policy, which is fairly easy to do most of the time. So those are our recommendations, and with that, I'm going to turn it back over to Julie to see if there's any questions that we can answer.
Great. Okay, thank you very much, Linda and Marla. Every time I hear this webinar, I think, oh, gee, I have a situation that I am not classifying an employee or handling an independent contractor quite the right way. So thank you for sharing all of that. That does conclude the webinar presentation portion, and now we'd like to spend some time asking or answering some of your questions. The way you submit a question is by using, and I see some of you are already doing that, use the question portion of your dashboard. All you have to do is in the empty box at the bottom, type in your question, hit return, and I will be happy to ask that of Linda and Marla. And you may also, if you choose, email the questions directly to me, julie@thedoorgroup.com. So let's start with one here from Jennifer. And I think you covered this, Linda, but I just want to make sure we've got the right answer here for Jennifer. She has an employee, maternity leave, wants to stay home, be more at home with mom and have more flexibility with schedule, wants to go from full-time employee to independent contractor, which Jennifer's okay with, but what would be the best way since the work schedule isn't going to be as defined as it was before, clearly, and Jennifer wants to know what they should do to protect themselves.
Yeah, great question, Jennifer. And what I would recommend is this, if they're going to be doing the same job they were doing for you as an employee before they went on maternity leave, most likely they're still an employee. So it's fine. There's plenty of companies that allow people to work from home, telecommute, and they can just be on payroll on a part-time basis. So that's easy. You can just keep them on payroll. They were on payroll before. Keep them on payroll. Change their status. It'll probably change their benefits depending on how many hours they're going to work. But if they drop below 30, as an example, that'll often change their, paid time off benefits as well as health insurance benefits. So that's the conversation I would have with the employee. But I would just, if it's okay with you guys to have that person work from home, I would issue them whatever status change type form you use, a new offer letter, whatever you want to do, and spell out for them how it's going to affect their benefits and leave them on payroll. I think that's a much safer way than all of a sudden calling them an independent contractor.
Okay, good. That's a great answer.
Can I add something to that, Julie?
Oh, yes, absolutely.
Whenever you have someone who has been an employee and you change them to independent contractor status, it's a red flag for the IRS. It's highly suspect because it's very, very rare circumstance where an employee changes from an employee to an independent contractor. It's not unheard of, so let me give you an example. An employee who is your inside IT person who's been working for the company for years, works 8 to 5, handling all IT matters, decides to go out and open his own IT consulting business. He's not going to just work for your company anymore. He's going to work on call for companies, troubleshooting. So when your system goes down, you call him. He comes in, he fixes it. But then when company B's system goes down, he's over there. He sets his own prices. He has his own tools. That's someone who has converted properly from an employee to an independent contractor. But it's the very rare circumstance that happens. Usually it's an employee who kind of sounds like Jennifer's situation, is working as an employee, but now it's just going to work less and wants to work at a different location. That does not meet all those tests, where you need to have that potential profit and loss, you need to have that potential investment, capitalization involved, and then you need, more importantly, to know who's controlling the work that's being performed.
Okay, great. And Marla, you must be reading the questions ahead of time, because Bob asked that same exact question. They have a former employee who's retired. They want to bring them back to help with some computer programming. And the question was whether, and he's also doing some separate work as a IT consultant. So Bob was asking if they should bring them back as a part-time person, but I suspect the person.
So I'm not reading the questions ahead of time because I can't see them, but it's the same analysis for Bob, and it's, you've got to go through all those checklists, and like Linda said, we're going to send out to anybody who's interested a questionnaire to kind of help with that analysis. Just to point out how difficult this is, if anybody's interested, you can go to the DLSE's website, and on their own website they discuss the possibility of the DLSE determining that somebody is an employee, and then the EDD subsequently determining that same person is an independent contractor, because they don't always analyze the test exactly the same way. And you can see sometimes it's a little blurry and gray, the answers to these questions that we're giving you. So it's really difficult. Sometimes I tell clients, just err on the side of caution and make them an employee. And other times I say, I feel very strongly that this person's going to meet all the independent contractor questions and meet that analysis. But it can be a significant and extensive analysis sometimes, especially if there's a lot of them. But I do want to point out to everybody that most of my employers do not misclassify willfully. As Linda and I both talked about the California independent contractor law. Most of my clients, it's an honest mistake. They're not trying to avoid paying taxes. You've got an employer and a worker who want it to be independent contractor. A lot of times they say that what they think that means is that the other person gets to control the hours that they work. And it's more than that. It's not just hours. It's all those factors. But most people don't make this mistake intentionally. Some do, but most don't.
We've learned our lesson, I think, over the years. Yuki's got a question here, and I'm assuming, Yuki, this is for the independent contractors, is asking, can we require a non-compete? And again, I'm assuming that's for independent contractors.
Not in California.
Okay.
Non-competes in California are only enforceable if they're given in connection with the sale of a business or the sale of an interest in a business. And the sale of an interest in a business has to be enough to have also sold goodwill. Now, that doesn't mean you might not have trade secrets that you can get the independent contractor and the employee not to use after the work has expired. So if your customer list rises to the level of a trade secret, which is really difficult now with the internet, but if it does, and some do, or if you are the holder of the formula for Coca-Cola, which used to be a secret, you can still prohibit workers of any kind from using that, and anybody else for that matter, from using that information.
Okay, good. Thank you. John's got a good question here. Can an employee also be a 1099 independent contractor relationship for different work being performed by the same employer?
Yes, but again, red flag. So make sure, when I say red flag, just make sure that you're very confident that on the independent contractor side they can do that. So let me use my example of the IT guy who goes out, starts his own business, has his own trucks, has his own tools, has his own employees and assistants. That was one of the tests. But for you, what he does is he's janitorial during the day. So from 8 to 5, he works janitorial, or maybe he works on a production line. It has nothing to do with computers, but he happens to be a great IT guy too, and he has that business on the side. If the separate work meets the test, yes, you can have both. But remember, you're going to have the IRS looking at 2 Social Security numbers, sometimes the same. It's much, much better and much less risk if the independent contractor has an entity, such as a corporation or an LLC. because then they're not going to see that it is the same Social Security number.
And Marla, that's a really good point. I don't think people realize that. That's how a lot of people get caught also by double collecting like a wage and unemployment, or a wage and workers' comp, or a wage and whatever else, disability, right? The government's not stupid. They know how to run database searches, right? And they can put in a Social Security number, and everything's tied to that. So your W-2 is tied to that. Your W-9 is tied to that. So it's really easy for them to say, hey, did this person collect under a W-2 and a W-9 during the same fiscal year? And if the answer is yes, I don't want to, I don't want to have that happen to me, because that is just a huge red flag for an audit waiting to happen. So, like Marla said, just be really careful. Can it happen? Can that be a true scenario where they could be both? Yes. Just be really, really cautious on that one.
Okay, good. Thank you. And B has a good question about how to deal with temps and the treatment of them. She's working with a staffing agency, and they include temps in company picnics and company events type thing. But moving forward, does that blur the line, and should they not include the temps?
I don't think it's the same situation, me personally, because temps are actually workers. You're paying them a wage. You're not paying them as independent contractors. So I think it's a little bit different. I didn't mean to scare anybody off of inviting their temporary staff over. There's a whole separate issue that, Marla, maybe we should think about, talking about a future webinar about joint liability situations in California, because a lot of times, people think, oh, I'm going to get temps through an agency because then it's going to be their liability and not mine if something happens. There was recently, OSHA came out, and I don't hold me to exactly quoting this, but the gist was OSHA came out and said, if somebody gets hurt on your premises while they're at work, it's pretty much you have to list it on your OSHA 300 log, even though they're through a temp agency, because for the most part, unless you have a large enough contingency staff where you have a manager from the agency on site to manage that team, they're taking direction from your managers on your team. So it's a different question with a slightly different answer, but no, I think it's fine to invite your temps to participate in everything at work.
Okay, good. Anything to add to that, Marla?
No, I agree 100%.
Okay, good. Vicki has a question. She once had exempt employees in a house cleaning business, and as a result, she provided the cars, the materials, the training, the cleaning supplies, and then changed them over to independent contractors where they had to provide their own transportation, chemicals, and she did no training. And then she said, I provided the clients they already serviced as an EE. With this info, was this done correctly? So
probably not.
Probably not.
I would want to do more analysis, but probably not, because again, it's the same work that was being done. My guess is that she was setting the hours of when they were going to go to client A and client B. If she had just given them a list and said, okay, you set your own time to go to client A's and client B's, and all we will do is collect the money for you, take our cut for making the introduction, then maybe that, we see that a lot. I think Linda gave the example of a teacher. We see that a lot with teachers and musicians. If the instructor has the ability to set their own schedules and to set their own fees, then the other party is merely just collecting those fees, servicing the fees, and then taking their cut for introductions, then we actually have an IRS opinion letter that is independent contractor status. But if the person who asked the question was setting the hours and setting the schedules and saying this is where you're going to go see client A on Monday, you're going to go see client B on Tuesday, then probably not.
Okay, good. All right, thank you. And Claire has some questions here about the inconsistencies between the different, federal entities that would be the ones making the changes and classifications. So if one Fed entity might determine or rule differently than the other, what are they to do? What's Claire to do if they don't agree?
That's a great question, Claire. That's a really great way to end the thing to show how it's a difficult thing. I have personally, and maybe Linda you can address this, I have never had a client who had a different ruling from different entities. The example I gave was actually two state agencies, not Fed and state. I would suggest you sit down with your lawyer, because every one of these things requires, again, extensive analysis to make a determination. especially the part that Linda spoke to about doing the voluntary settlement. I think you need to look at the risk of what if the EDD, and look at, when I say look at the risk, look at the numbers. What numbers are you talking about? But that's a good point. Again, this is an area that you have to kind of take it as it comes. But what do we do if the IRS says it's an employee, or we're more fortunate, the IRS says it's an independent contractor and the DLSE says it's an employee? You have to go with what's more protective of the worker, and that's going to be employee.
Okay, great. Brenda has two different scenarios, and I'm going to cover each one, let you answer the first one first, and then I'll cover the second one. First, they did a layoff earlier in the year, and they laid off 2 IT individuals. Why do these things always happen with IT people? Then she opened a new business and brought back these 2 individuals as contractors, and a contract was provided to them. But they're sitting in their previous desk office. They're directing employees, approving employee timesheets, and typically come into the office every day. This is an employee, right? Is what Brenda's asking.
Probably.
Right.
Yes, but the attorney's
Right.
like, well, probably.
Yeah, the attorney's always going to give you that answer.
Okay, so Brenda, we've got one that's an employee, or 2, I guess, IT people are employees. And then the second scenario is we have an individual recommended by one of our directors. He comes to work most days. We provide most tools, and he also drives our vehicles and performs work at our stores that is directed by us. He submits an invoice weekly with detailed work details, and we pay him weekly by our AP department. Is this an employee? Question mark?
Probably.
Yeah. Marla with her probably. Linda, come on, give me a definite.
Yeah, no. Yeah, probably.
I would need a lot more information to take him out of the right now. Everything you've told me suggests employee. But if you came back and said, well, he's also doing this for 3 other companies. He has special skills. He's got a corporation. If there were some other facts, I might say, you might get over to the independent contractor, but right now it's all leaning towards employee.
Right. Let me give you another example, okay? When I first started my business, I did some work for a company where I was, they basically were outsourcing their recruiting efforts for me while they were looking for a recruiting manager, which I was actually hiring. So I was doing the recruiting as I was hiring them a recruiting manager at the same time. They didn't have to provide me with tools, an office, any of those different things. I could have done the work from home. I was doing work for other businesses, but it was easier for me to work out of their office, right? Because if I'm going to interview somebody and then I want to get the hiring manager involved, or I want to pick up the phone and talk, dial an extension for a hiring manager, that's a heck of a lot easier than it is if I have to dial all 9 digits from home, right? Or if I want to walk down the hallway to talk to somebody. So I'm comfortable that I was working as an independent contractor. I was setting my own hours. I had the list of openings, and I was doing that work. So even though I was on site and I was, once in a while participating in a meeting or something like that, it's a completely different thing than had I been there with somebody telling me what to do and I'm reporting into the, VP of HR every day or something like that. So you got to take a look at the circumstances entirely. I think that's what Marla's point has been all along. It's not one of those 20 factors on that sheet. You have to take a look at all of them. And there's unfortunately no test where you can say, oh, well, if you have this one factor or this combination of factors, then you're fine, because it is gray area. It is subject to interpretation.
Okay, good. And again, for all of you listening in, don't hesitate to email either Marla or Linda with these questions if we're not getting into enough detail for you today. Again, all their contact information are in the slides. We've got a question here with Debbie. The company's doing employee wellness, and they bring a yoga instructor on site, and they subsidize the class. So they're providing her the space to do the yoga class and paying the instructor to come in. Is that a contractor? And specifying the time, sorry about that, and they specify the time that the instructor comes in. Is that an employee or a contractor?
I'm going to guess that that person's probably going to be a contractor, assuming that they're doing that same thing for other companies, right? If they have their own business. And yeah, they're not going to set their schedule because it has, there's times where I go into a client and they have to have me there at a certain time. That by itself is not going to invalidate the contractor agreement. right? So assuming that that person isn't only doing it for that one corporation, that they're, you know, it's part of the wellness program that they're offering to many different clients, that's probably fine. Marla?
Yeah, I agree. Again, it's not the one factor. And when you say, well, the employer is dictating the time, they're actually coming to agreement about the time, because the yoga instructor could say, no, I have another class that day. How about Tuesdays at 4 instead of Wednesdays? So there's negotiation. It's not a you will be here or you don't get paid on that particular day. Usually, you know, again, it all goes to the other factors Linda discussed. Is that yoga instructor working for others? Does that yoga instructor a corporation or an LLC? That helps tremendously. Does the yoga instructor bring her own mat or his own mat, or is the employer providing that? What about music? What about training videos? Are they using any of those things? And if so, who owns them?
Okay. Yeah, the employer is probably not telling a yoga instructor how to conduct a yoga class, right? I mean, they're bringing that person in because that's, you know, his or her expertise. So.
Perfect.
And
well,
that's really good, because it goes to the fact that it's not in the employer's, you know, direct line of business, and so unlikely the employer is giving any direction or control on how to do the job.
Right.
Okay, good. Well, and on that note, namaste, we're going to wrap it up today. That's it for questions. Linda, we have a list of the webinar schedules up here. Do you want to just really briefly, we made a little switch, can you maybe explain to us what's going to happen
Absolutely.
Here?
So if you look back through prior webinar handouts, we did make a change. We changed August and September. We flip-flopped them to accommodate our guest speakers. So just make a note of that. So we're really excited. Next month, August 14th, so that's actually, seems like it's going to be very quickly. We're going to be talking about immigration law, and this is a new topic for us, and so we brought in an attorney that actually specializes in immigration, Greg Berg, who's a partner with Carruthers, DeSante, and Fernberger. So we're very excited about that, August 14th. And then September 25th, I believe Tim did a webinar for us a year or two ago. We're going to be talking about background checks. This is something that's just come up recently for me over and over and over again with clients. So what should you be doing in terms of background checks? What legally can you be doing in background checks? What kind of policy do you need to have with regard to background checks? Can you have policies? The answer is no, but can you have policies that just say we don't hire anybody that has a felony conviction? Things like that. So that's what we're going to be talking about. October, we'll talk about drug testing, because there's a whole bunch of issues around that, medical marijuana laws, everything. And then in November, one of the tried and true favorites that we have just a ton of people on this webinar is about disciplinary action and terminations.
Great. Well, thank you again for joining us. Again, we highly highly recommend that you contact Linda or Marla with other questions. I know you have, more specific scenarios and things that you might want to run by them, but again, you've got not only the HR professional, but the attorney that would certainly be able to help you with any of these classification kind of issues. And then, of course, we do have a link here for you to go ahead and save the date. So again, with all of our webinars, you can go in and click and reserve a spot. We have limited seating for these webinars, and they're gaining in popularity, so please go ahead and sign up ahead of time. And then on behalf of Linda and Marla, I'd like to thank all of you for joining us today. We certainly appreciate your time and your attendance today, and we look forward to presenting more of these to you in the future. Thank you very much. Have a great day.
Thank you.